Reduction of share capital under Companies Act 2013. Sometimes company on account of reorganization need to reduce share capital, so the question arises how to reduce share capital under Companies Act 2013. The provisions to reduce share capital is covered by Section 66. Read with relevant rules under Companies Act 2013, subject to confirmation by the Tribunal on an application by the company, a company limited by shares or limited by guarantee and having a share capital may, by a special resolution, reduce the share capital in any manner and in particular may alter its memorandum by reducing the amount of its share capital and of its shares accordingly. What are the ways to reduce share capital? Extinguish or reduce the liability on any of its shares in respect of the share capital not paid up, or either with or without extinguishing or reducing liability on any of its shares, A. Cancel any paid up share capital which is lost or is unrepresented by available assets, or B. Pay off any paid up share capital which is in excess of the wants of the company. Point to be noted, no reduction shall be made if the company is in arrears in the repayment of any deposits accepted by it, either before or after the commencement of this Act, or the interest payable thereon. What happens after the application is submitted to Tribunal? The Tribunal will give notice of every application made to central government, registrar and to the SEBI in case of listed companies and to the creditors of the company. Once this is done, it will take into account the representations or issues brought into notice by various authorities including creditors. When the reduction of share capital is confirmed by Tribunal, there is a time frame of 3 months in which SEBI, registrar, central government or creditors can make representation. If there is no representation received from them or if the Tribunal is satisfied that creditor claim has been discharged, secured or there is consent from them, then Tribunal passes the order of reduction of share capital. What is the procedure to apply to Tribunal? An application to the Tribunal to confirm a reduction of share capital of a company shall be in form number RSC1 with prescribed fees. Following documents have to be attached: list of creditors duly certified by the managing director, or in his absence, by 2 directors, as true and correct, which is made as on a date not earlier than 15 days prior to the date of filing of an application showing the details of the creditors of the company, class-wise, indicating their names, addresses and amounts owed to them. Certificate from the auditor of the company to the effect that the list of creditors referred to in is correct as per the records of the company verified by the auditor. A certificate by the auditor and declaration by a director of the company that the company is not, as on the date of filing of the application, in arrears in the repayment of the deposits or the interest thereon. A certificate by the company's auditor to the effect that the accounting treatment proposed by the company for the reduction of share capital is in conformity with the accounting standards specified in Section 133 or any other provisions of Act.